Welcome to Employment Law This Week. I'm George Whipple. Our top story, out-of-state contractors could be liable for directing background checks on independent contractors in New York. 2 workers were terminated after their criminal history was discovered during a background check. They worked for a New York company whose contract with a national company required their termination. The employees sued both companies under the New York State human rights law. Addressing the law's criminal history discrimination provision, the New York State Court of Appeals held that only an employer can directly violate the statute. But an out-of-state company that requires a New York employer to discriminate against employees or applicants based on their convictions can be held liable as an aider and abettor. Nancy Gunzenhauser has more.
There are 2 important holdings for out-of-state employers from this case. First, out-of-state entities, whether they're an employer or a contractor, may be held liable under the aiding and abetting provision of the New York State human rights law. These entities may also be considered joint employers under the New York State common law by following the 4-factor test. Employers and contracting entities outside of New York should be mindful that they may be held liable under the New York State laws.
No reversal on Weingarten rights for non-union employees. Weingarten rights come from a Supreme Court ruling that union workers are entitled to have a representative present with them during any interview that could result in disciplinary action. In this case, the NLRB declined to reverse its 2004 ruling that non-union workers are not entitled to have co-workers present during such an interview. And some news on the challenge to the Persuader Rule. As the new Labor Secretary adjusts to his new role, the Trump administration has asked 2 federal courts for an extra 2 months to determine its position on the rule. The Fifth Circuit clarifies the legal standard for determining whether documents subpoenaed by the EEOC are privileged. An employer in a discrimination case withheld documents and asserted attorney-client privilege. The district court placed the burden on the EEOC to show that the documents were not privileged. The Fifth Circuit reversed, holding that the burden is on the employer to provide a privilege log with enough detail and supporting evidence for the court to make a determination. The Fifth Circuit remanded to the district court to apply the standard and conduct an in-camera review of the documents. Finally, New York City's Freelance Isn't Free Act takes effect today, May 15th. The law establishes rights for freelance workers, including the right to a written contract, timely and full payment, and protection from retaliation. And Mayor Bill de Blasio has signed the city's ban on inquiries into salary history. That law will take effect on October 31st of this year. And that brings us to our tip of the week. Claire Cosbar, Senior Vice President of Human Resources and Administration for In Demand, is here with some advice on attracting and retaining millennials.
By 2025, millennials, those born after 1980 and before 2000, will make up approximately 75% of the U.S. workforce. So what can companies do to attract millennials? Well, first of all, they can offer development opportunities, things like seminars, tuition reimbursement, internal and rotational development programs. 8 out of 10 millennials also want some type of mentoring program, and 95% of them want to participate in a leadership program. Additionally, you can also provide a sense of purpose. Millennials want to know why they're doing what they're doing. And so giving them some more information and also tying it back to company values will help to retain your millennials.
Thanks, Claire. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.